Okay, this is Julio Zamora. I'm making a statement for Settlement Conference Judge Grill in Stockton, California. My name is Julio Zamora. I live at 1385 El Camino Way, Los Banos, California, 93635. My home phone number is 209-829-1787. This statement is for the Settlement Conference, Judge Grill, Administrative Judge. The fact that is that the union didn't follow contractual procedures and didn't meet any time limits whatsoever. And the fact that that on December 7, 2010, they flat out sent me home. Didn't give me anything in writing or registered mail or anything else to intent to discharge or intent to suspend. Nothing. I just sat at home waiting for registered mail or a phone call or anything to return to work according to the notice of offer of work that I received on November 1st, 2010. I took a QME physical in the month of October 2010, and it wasn't honored on December 7th, 2010. I was flat out sent home, and the company did not comply with any time limits with the union. A union agreement made between Local 439 in Stockton, California, and Safeway. And I should also note for the record that they tried to discharge me on December 16, 2010, and it was denied on December 17, 2010. And I'm assuming because Safeway did not meet one time limit, null and void, final and binding. I'd like to make that statement for the court, and the fact that I request to go to trial or appeals court or whatever it may be due to the fact that I took a hearing examination according to the QME report, and it was discovered the fact that I have a hearing impairment since 2006, and I wasn't accommodated or aided in any way or even received any hearing aids since 2006. They did not comply. I was not accommodated, and they refused to put me back to work full duty release. According to the EDD, that I gave Safeway a full duty to go back to work, and it was denied, and it was established the fact beyond a reasonable doubt that Safeway is in conflict of liability. From 3/21/2009 or 4/17/2009 and ongoing. I received another letter in 2012 or 2013 that Safeway is still in conflict of liability. I should be working. And again, for the Administrative Judge Grill at Settlement Conference, my request is that this be forwarded for trial or appeals court or wherever Administrative Judge Grill thinks that it should go to or referred to. For the fact that I request that my case be heard in court for hearing impairment, which I'm protected under the federal government of the Disability Act that was amended in 2009. I'd like to note that for the record. Today is Sunday, March 3rd, 2013. Another notation for the record for court. The fact is, I took a QME report in October, and in the QME report, it states the fact that he doesn't do hearing tests, and the QME report wasn't complete, and that Adam Stewart didn't send me to a hearing doctor to have a hearing test, and the fact that he wrote down that I had a permanent disability and how much it was, and the fact that I filed that I had a hearing impairment in 2009, and when I went to settlement conference, nothing was on the table for Judge Grill. The QME report wasn't complete. The severe profound hearing impairment wasn't on the table. And the fact is that, like I said before, they just flat out sent me home, and the QME report wasn't finished. and I didn't do anything wrong. I'm innocent. And the fact that they called up and the Health and Welfare Department and said I didn't work there anymore was a mistake, because I paid for that lifetime medical, and I could have retired any time after 2002. 2003 or 4. I could have retired at any time and had lifetime medical with no premium. And I have a disability, and in fact, I didn't realize how severe my hearing impairment was. So they need to honor the notice of offer of work. They knew I had a QME report that I had a permanent disability and that I was on FMLA, and the QME report wasn't complete. And they just flat out sent me home, and then said that I was fired on December 16, 2010, the union attorney, when in fact they didn't follow contractual procedures. And most important of all, they didn't notify me that I was suspended or fired or anything else. They just flat out sent me home. I can assume anything at that point, but I didn't, because I have 200 employees underneath me and I didn't do anything wrong, and I have a permanent disability. In fact, on top of that, when the QME report was complete, I should note that for the record, that I'm deaf. I have a hearing impairment. And according to the 2009 Disability Act, which I'm protected under by the federal government, for people with hearing impairment. So, and I don't know what the workman's comp rules are, or if the Disability Act applies in this situation. So that's why I'm requesting to go to trial. And I'm also requesting that Mr. or Mrs. MORLES replace my lifetime medical immediately by court order. For the fact that Safeway called up and I don't have no lifetime medical for myself or my family, or to cure or relieve pain and suffering from the on-the-job injury. So, and I'm guaranteed that 1 year, and I need that 1 year. So again, the reason for the notation is the fact that the QME report was not complete, and it states in the QME report that he doesn't do hearing tests. So Adam Stewart was required to send me to a hearing to get a legal document, which he didn't do, in October, when the QME stated and made a statement in the QME report the fact that he doesn't do hearing tests. So that's all I want to make a notation to the court, and I need to remember that to bring it up to Judge Brill in the settlement conference. A request for trial that the QME report was not complete, and it states in there that he doesn't do hearing tests. But the fact is, he did state I have a permanent disability, and I could do my job. Okay, so and the fact that that when they were aware of this, they just flat out sent me home. There's no need to go into about the dispatcher or anything else. There's no doubt that that man is guilty. And there's no doubt that the fact that they had a no-fault attendance policy for geez, maybe 30 years, 40 years, who knows, but they've had it for such a long time, it's just unbelievable. No-fault attendance policy. So, so I'm innocent. There's no doubt about the fact that I'm innocent. They sent me home because I have a disability, and I have a hearing impairment. There's no doubt about that, because the QME report is now complete. And when I go to the settlement conference, when I get my court date, I'm going to make that statement under oath, and I'll have a notice of offer of work. I'll have a legal document that I'm deaf, that I have a hearing impairment, and that I should, and I have, that I should be returned to work according to the notice of offer of work that is supported by a QME report, uh, from October, and the fact that, Adam Stewart didn't put all that on Judge Grill's desk, so I'm asking for enforcement of that notice of offer of work, and whatever I asked for in my other statement. But the point is, not to make a long story, a short story into a long story, which I'm rattling on, because I do have a profound hearing impairment, and it's really bad. It's really bad. My wife is irritated. I'm talking really loud, and it's just I need to be returned to work. I can do my job. I don't have a problem doing my job or going to work or anything else. I need that 1 year, and it's very important. And I shouldn't be denied that 1 year, no matter what. So I'm going to ask Judge Grill if he could do that, and if the union was correct in sending me home and not accommodating me with a listening device at the panel hearing, when they just flat out sent me home and didn't finish the panel hearing. So that's why I need to go to trial. That issue, and the fact that my lifetime medical insurance, that's also an issue, needs to be resolved by the court, by Superior Court, or the workman comp judge. I need to go to trial. Because it's not right. I informed the union that I had a severe profound hearing impairment, and they made the statement, the fact that they were aware of it and I had disability issues. And the fact that they just flat out sent me home and didn't finish to complete the panel hearing, let alone produce any evidence why or why not did they send me home. They just flat out sent me home. Nothing in writing or that I was suspended or anything else. They just didn't do anything. And I don't even know why I'm sitting at home. Why am I sitting here? I don't have any documents that states why I'm not working. Not one but registered mail or time limits. Not one document explaining to me why I'm sitting here waiting for a phone call or registered mail to report to work. And it's going on 3 years. I don't have one document. Not one. So I should get paid. From December 7, 2010, there's no doubt about it. I should get paid. This is just nothing but harassment. And it could be retaliation. I don't know. That's why I need to go to trial. I need to know, find out why this is all happening. I wasn't informed by the time limits or any other thing. No registered mail, not one. You know, not even a Dear John letter, nothing. And I haven't been able to get treatment or anything else. And I've had to pay for my own payment with my acupuncture, and I can't get her as an acupuncture for my treating physician because her name is not on the HMO list. So I got to go to this other one, and I really don't want to because I've been treated by this other lady for so long. I don't want to start all over again. It's crazy. So I'm going to have to wait until I go to trial and try to, you know, get by. But I need to return to work. If I can just get to work and get my back pay, I can get my own organic medicine, whatever it is, and take care of myself until I get my lifetime medical. And then I can go in and get my pinched nerve fixed because I got medical insurance for life. And I'm being denied the right to get my disability fixed or cured or relieved from any stress or pain from the on-the-job injury because of their actions. And like I said before, I don't have one document of why I'm sitting here. Not one. I have no registered mail. Not one. Not one registered mail. Never mind what Niswanger, he's not Safeway. He's the union. They don't have the right to say I'm fired or I'm being disciplined or anything else. Safeway needs to inform me of what's going on, not the union. And the union didn't do anything. I mean, I had to wait till 2011 to actually find out what the heck is going on, because there was nothing showed to me or registered mail of what this was all about. That's insane. And I have a permanent disability. Nothing was put even on Judge Grill's desk. He don't even know what's going on. So, I don't know. I need to go to trial. And I need my lifetime medical returned immediately. That Safeway private insurance in Arizona needs to replace that lifetime medical. So I'm going to request that in court, that they return that lifetime medical, because there's no reason why I should not be covered with lifetime medical that I paid for in 2003. And I could have retired any time after that. I could have retired. I'm qualified to retire now. But I need that 1 year. They offered it. It's an agreement. So I need to go to trial, because I'm being persecuted and I'm being sitting here, and it's really hard. I'm a good worker. I didn't do anything wrong. You know, it's just not fair. I'm dragging on with this notation again. I wish I could stop repeating myself over and over and over again. And they need to accommodate me with some hearing aids. I got to tell you, I bought the first pair, but they're not right. They don't block out background noise or static or this or that, you know. And I got to also remind myself, on December 7, 2010, that dispatcher, he was loud. I don't know what he said, but he was loud. I had to step back because he was waving his hands and this, and all this. I didn't know what the hell he was talking about. I mean, the guy was just frantic. I mean, Jesus Christ, man! I really walked into it on that day, and I did my work. I didn't do anything wrong. You know, I mean, there was no need for all of that, raising your hands and just bragging to everybody how I got. Julio's got what? I got nothing in writing, nothing stating why this or that or anything else. So I was falsely accused of whatever it is. I was falsely accused. I know I found out something in January 2011 when they set the panel date, which they shouldn't have. I should have went to Board of Adjustments. But even then, what was I going to Board of Adjustments for? I don't even know. I don't even know what this disciplinary matter really is, because I was never notified and they never produced one document of what the disciplinary action was about. Not one. And the fact that they didn't meet the time limits like they do for 1,500 other Teamsters and put them back to work, there was no reason why they shouldn't put me back to work. And James Williams, the transportation manager, it falls on his lap, because he's responsible. He's oversight for Mike Sadler and the rest of the transportation department. So I'm not going to make any accusations in that respect, because I'm going to let the judge do it. Let him decide what's correct, and let him tell me why was I sent home on December 7, 2010. I received a notice of offer on December 1st, okay? On the 3rd, I went to work. On the 5th day of work, he just flat out sent me home. And the rest is history. And the QME report wasn't finished yet, but yet they offered me a year worth of work, and the QME report wasn't even finished. It wasn't complete. So, I don't know. I'm looking into this thing, for going on 3 years, trying to figure out because I'm innocent. I'm fighting back, and I just don't get it, man. I don't feel guilt ridden. I don't feel guilty about anything. I just don't get it, and I can't figure out why they shouldn't pay me back pay. I'd sure like to know why they shouldn't. They didn't notify me of anything. They have no excuse why not. And even though I can't get employment because of the said actions of the dispatcher and their said actions, it still wouldn't matter anyway because I didn't do anything wrong. I have to sit here and wait to be called for work. It's true. Because if I'm not available when they call or call back, when they call me for work, they can fire me. So I wasn't notified. I was sent home. I got to sit here and wait. I wasn't notified. The QME report wasn't finished. They knew I had a permanent disability and a hearing problem. They knew all of the above. And I knew nothing of the below. So now I'm sitting here waiting to go to trial. And I got to tell Judge Grill I need to go to trial. This needs to be heard in trial and find out if they're guilty or not. And I need my lifetime medical and notice of offer of work to be enforced, and I'm to be allowed to report to work one way or the other. Because they don't comply. They don't comply, obviously. 3 times they didn't comply. They didn't comply with the contract. They didn't follow contractual procedures. They didn't follow the administrative judge suggestion. And I have a witness to that. And they didn't comply when the union attorney sent me to work. They didn't comply then either. And I guess they're not complying with the private insurance company Safeway in Arizona. So that could be 4 times. They're just not complying. The insurance company is telling my attorney, okay, I see the company offered you work for 1 year. Okay, go ahead and send this guy to work. Well, so what's going on? Well, I'm not working. Why wasn't I working then? They shouldn't have sent me home. They should have completed the QME report before they sent me home. Okay, so they don't complete the QME report. They send me home, and then on the 16th, the union attorney, with no evidence, nothing whatsoever in his hand, and knowing about the fact that I have a hearing impairment, decides not to follow contractual procedures. With no evidence, not one point can he state why I'm staying home, and I was notified according to contractual procedures. Now, I'm not accusing the attorney of not following his own contract or arrangement with local 439. I'm going to let the judge do that. Really something, huh? An attorney. A lot to be said about that in court. So I guess we'll find out when we have discovery. And I don't know. My kid's life is at risk. My wife is sick, and I'm going through all this. And there's nothing in writing. I received nothing in writing of why. That I have to sit here and wait for a phone call or registered mail to report to work. And why, not one good reason why that I lost my lifetime medical that I paid for or contribute to. I paid 5 years ahead. They called up Health and Welfare because I called them and they said, no, you don't work there anymore. So I lost it. They need to replace it. Safeway private insurance company needs to replace my lifetime medical insurance. But the fact that on December 7, 2010, or in October when they made the QME report and the doctor says I don't do hearing, the QME report was not complete at that point. And the fact that they took it upon themselves to send me home with a permanent disability and the QME report not being complete, and the union attorney not allowing me to go to arbitration or finish the panel hearing regarding the QME report not being complete, or having me sent to a hearing specialist to find out if I'm telling the truth, he got the cart before the horse. And not even the union attorney can produce anything that why I was sent home. It's just the garbage. It's useless. The statements are useless. They have nothing to back it up with because they didn't send it within the time limits. So their statements or anything that they say is null and void. So they don't have any grounds. Because according to state law, my assumption is they have to give me something in writing or let me know why they sent me home. They got to tell me something. They got to notify me. I don't see anything in the law that says they can take my lifetime medical away and just flat out send me home and accuse me of making false accusations that they can't back up. Did an injustice occur? I'm sure it did. So we're going to find out in discovery exactly why am I sitting here? And is it proper? Okay? I should get all my money back. And my money back and plus whatever the Disability Act calls for. So, I'm asking for trial, and I need to note this and make sure I bring it up to Judge Bill, the fact that Adam Stewart didn't put anything on the table. The fact that I wasn't notified at any time, place, or anything else of why I was sent home. Nothing in writing. In fact, when they sent the letter to me from the union attorney to my attorney that I was discharged in December 16, 2010, they didn't state why. Didn't make one statement on why or any evidence or the fact that I was handed something in writing according to the contract when they sent me home of why I was being sent home and required to go to Board of Adjustments within 30 days of time of incident. No documents to show why I was sent home within the time limits. Nothing in writing. Not one thing. It's just gossip. Those are the facts. So there's no evidence. There's nothing. They didn't give me anything which is required, and they just went ahead and did whatever they wanted to do without following the rules and regulations and contractual procedure. And they didn't follow workman's comp rules and regulations. There's no doubt about it because the QME report wasn't finished, and they went ahead and fired me while I was on disability, and I had a severe profound hearing impairment. And there was no reason why they sent me home before December 16, 2010, because I wasn't fired on December 7, 2010. And I wasn't disciplined for December 6, 2010, because there's nothing in writing. I didn't receive any registered mail or intent to discharge or suspend. Not one thing. And they had no right taking my lifetime medical away, which they have to replace. I'm asking the judge to have it replaced, court order. So it seems to me that everything has to be a court order. And I guess it's up to Superior Court to close them down because they can't operate without insurance. And if they don't comply, that's cause. All they have to do is show cause. That's all the judge has to do is show cause and cancel their insurance. Safeway Incorporated. So I can show cause that I shouldn't have been sent home. And upon discovery, I'm sure it's going to come out the fact that yes, I wasn't notified or intent to discharge or suspend. Nothing in writing. Just false accusations and nothing to back it up. And I would assume that the union attorney made a mistake because he acted without cause. without justification, without no evidence, within the time limits, within contractual procedure. The union attorney, it's not for me to say, but that'll be for the judge to say. So, and the fact that Mike Niswonger didn't complete the panel hearing, that's another one that the judge will have to take into account under the Disability Act of 2009. Because the unions or anyone else are not allowed to discriminate against the people with hearing impairment. And so the union is protected, but not under the Disability Act of 2009. So the union is not taking any step to get me back to work, and they have nothing in writing or statements within the time limits of why or who, what, where, and when. And then they had the right to send me home even though the QME report was not complete. And I gave them a copy of the severe profound hearing impairment to complete the QME report, and they didn't take it serious. They just didn't do anything. And they didn't do nothing within the time limits, and they didn't produce any evidence by December 25th, 2010, within 10 days. From December 17th to December 25th, I should say they gave until the 25th, but they didn't reply in 10, 20, or 30 days with any evidence or anything of that I'm guilty or what the reason is why they sent me home. Not one document within the time limit. They didn't respond within 30 days. That's what I'm talking about. There's no evidence to show cause. So, there I go rattling on. Oh man, I need to get back to work. So anyway, I'm asking for trial. So I guess that's it. I gotta remember this notation was about the fact that the QME was not complete. And the fact that the QME, the doctor said he doesn't do hearing. So that was Adam Stewart's responsibility to get me a hearing test. To complete the QME report, the fact that it said I had a permanent disability, but I don't do hearing tests. So they had no right to send me home on December 7, 2010. And they didn't show cause or anything else why. And I don't know, they're required to do so under the contract. But I don't know state law completely. So that's why we need to go to trial to decide if I'm guilty or innocent, and if they discriminated against me underneath the Disability Act of 2009 for the hearing impaired. So I got to remind myself before I go to court, and I'm waiting for my court date, or a phone call or registered mail. And that's my notation. That's what I come up with. I guess I had a nightmare last night, huh? Oh, shit. Well, that's it. That's my notation. Okay, I'm just going to add this to the end of that recording. I'd like to remind the court the fact that when I was sent home on December 7, 2010, when I received the QME report on December 1st, 2010, it wasn't complete. The QME report was not complete because the doctor, I forgot his name, said that he doesn't do hearing tests. And I received that on December 1st, 2010. Like I said, short story. I don't want to make a long story out of a short story. The fact is the QME report wasn't complete. They offered me work for 1 year, and I needed it enforced. Because the QME report wasn't finished yet. They just flat out sent me home. And I'm sitting here, and I don't know why I'm sitting here. They violated all the time limits. They didn't produce any evidence of what my disciplinary action is to be or what it was. by December 25th, and at least they had to put something in by December 28th, within 10 days. They didn't do so. They didn't do anything. They went around the Board of Adjustments, and that has time limits within 30 days. They didn't do that. They just didn't do anything within the time limits. And I don't know why I'm sitting here waiting for a phone call or registered mail to report to work when I have 200 employees underneath me. Now, James Williams, the transportation manager in Tracy, California, knows all this. He should have returned me to work like he does for 1,500 other Teamsters or 400 truck drivers. If it's not within the time limits, they're returned to work immediately. If it's not within the time limits, they're returned to work immediately. Now, I should note for the record, in Administrative Judge Grill, the fact that I don't know why I'm sitting here. They didn't produce anything. I never received any registered mail whatsoever of any suspension or discharge within the time limits. I did not receive one document of why I'm sitting here waiting for a phone call or registered mail to report to work according to the notice of offer of work that I asked for Eureka Run at 10 o'clock in the morning. And I'm still sitting here waiting. So I should get all that back pay because they didn't comply. 3 times they didn't comply. And I hate to keep repeating myself, but my life is on the line here. And I don't know why I'm sitting here. I don't have one document. Not one document for suspension or discharge, or the reason why I'm sitting here by registered mail within the time limits. Not one. And I'm still sitting here. So I should get all that back pay and benefits, and I hope Administrative Judge Grill returns me work according to the notice of offer of work that wasn't complete. They just flat out sent me home. And so I'm not going to go into it anymore about the deposition that I wasn't accommodated or anything else, and I need to take another deposition for the record. And that I have a new attorney, Modesto Legal Clinic, who took my case. Obviously, by my statement, you know why. The fact that Judge Grill didn't have nothing on the table, not my severe profound hearing impairment or the notice of offer of work. And that if it's at all possible, if Judge Grill could agree to the fact that Safeway should pay all attorney's fees and expenses to Modesto Legal Clinic for all their hard work and getting me to be returned to work. For the fact that Adam Stewart, I feel that he failed in his responsibility by not getting me a hearing test or not mentioning the fact to the Administrative Judge Grill that the QME report was not complete, and I didn't get paid every week or every 2 weeks, and that they're in conflict of liability with the EDD, Department of Unemployment. And he didn't mention one word about it since 4/17/2009 and ongoing, and I received another document from EDD saying that Safeway is in conflict of liability. I should be working. So with that being said, and the fact that Safeway doesn't want to comply, and it's just more time and money for Modesto Legal Clinic, who's representing me. And I don't feel I should have to pay Adam Stewart anything. So, but that's for you to decide what is fair and equal under the law. And your decision, I agreed to accept your decision, whatever is reasonable under the law. But I do request to go to trial to hear the case for the 202 Disability Act of 2009. Anyways, like I said, I have permission, or I was instructed to pursue this by the union attorney on workman's comp, and they're aware that I have a disability issues. I exhausted the union remedy. There's no remedy under the union to return me to work because I have a disability. And so they're not going to deal with it, and they threw it on workman's comp's lap. So, and the fact that I told them that I had a severe profound hearing impairment, and that wasn't acceptable, even though I sent them a prescription and the test results to the union attorney, and it wasn't accepted, and they denied me arbitration. And so I, Julio Zamora, invoke double standards. Life is not fair. Okay, today is Friday, March 1st. Making a statement for Judge Grill Settlement Conference in Stockton, California. On 3/21/2009, I was injured on the job, and I went to see Nancy Perdillo, and she stated that it was a sprain. I don't recall going to the hospital or an MRI being taken at that time. She's an alcohol and drug technician, which gives you tests to see if you were on drugs or alcohol at the time of injury. And there was no doctor present. Maybe a week or 2 weeks later, I ended up in the Los Banos Memorial Hospital with severe pain. It was really, really bad. I couldn't take it anymore. So I was there all night long, and they took an MRI and discovered the fact that I had a pinched nerve. They took an MRI the next day. I went in there for left leg pain, the same thing I'd seen Nancy Perdillo for in Tracy, California. Drug and alcohol technician who said it was a sprain. Now, I'm not going to go into the PR2 report because it's incorrect and it wasn't completely signed properly. And the fact is, I had a treating physician that I signed for good for 1 year, Paralosi, chiropractor. That if I get hurt on the job, that I'm to go to the company doctor for 30 days, and then the chiropractor is to take over. Okay, so and the Los Banos Memorial Hospital made out an occupational report stating the fact that I went in there for left leg pain, and that I have a low back, a pinched nerve. And I don't remember who I got the referral from, if it's Los Banos Memorial Hospital, what doctor it was, or if it was Dr. Yip or Paralosi. But they gave me a referral to Dr. Baby, and to fix the pinched nerve, it's a walk in and walk out type deal. And I was denied by Safeway, and they sent the letter to the wrong person, to Dr. Hubby, asking her if it was job related, the pinched nerve. And they should have sent it to Nancy Perdillo, the drug and alcohol technician, but they didn't do so because she's the one that said it was a sprain. So, okay, I haven't been paid every week or every 2 weeks, disability payments, since, I would say since 3/21/2009 or 4/17/2009. I had to file for unemployment, and they sent me a letter stating that Safeway was in conflict of liability, and they sent me another one in 2012 or 2013 that Safeway is in conflict of liability. I should note that I have a notice of offer of work that I received on December 1st. December 3rd, I went to work. On December 7th, 2010, they flat out sent me home. Just flat out sent me home. I had no representation. And the fact is, I was supposed to work first and grieve later. That didn't happen. They just flat out sent me home, and they made false accusations. And this is all disability related due to the fact that I filed in 2009 severe and profound hearing impairment from reefer noise. Come to find out, at the settlement conference, Judge Grill's court suggested that I get a legal document for severe profound hearing impairment, and come to find out that I've had a hearing problem since 2006. I needed to be accommodated with a listening device because I have a more than a 50% hearing loss in both ears. And I should note also for the record, since 2006, I have never been accommodated with any sort of listening device or hearing aids or anything else for that matter. It wasn't taken serious by the union or the company. But due to the fact that they had a panel hearing and they flat out sent me home when I mentioned the fact that I had a severe profound hearing impairment, and I asked the shop steward, "Are you an authority on severe profound hearing impairment?" And Mr. Nicewanger, the BA from the local 439 Teamsters in Stockton, California, which is a union shop, was there also, plus another shop steward was there when I made that statement. And he said he's going to look into it, and they just flat out sent me home and didn't accommodate me. And I should also note the fact that they didn't Safeway didn't follow contractual procedures. I was denied to return to work because they didn't comply with the time limits, like they do for 1,500 other Teamsters. I'll return to work immediately if they violate the time limits. They didn't do so. I should also note that they're required to go to Board of Adjustments for all suspension and discharges within 30 days. I should note that on December 17, 2010, Mr. Nicewanger sent a letter to the terminal manager, James Williams, that all disciplinary action to be denied and to send all proof, photos, evidence, whatever you have by December 25th to establish a fact beyond a reasonable doubt that Mr. Zamora did wrong or deserved disciplinary action, and to set a time and date. Well, the terminal manager, James Williams, did not comply. He set a date for January 11, 2011. I should note that's not within 30 days. According to the contract, all Board of Adjustment suspension and discharges are to be heard within 30 days of date of incident. And they didn't comply with time limits or anything else for the record. And on top of that, I was never notified that I was ever discharged by registered mail. I was never notified that I was ever fired, discharged, or suspended by registered mail, according to time limits. Okay? And so going from there, they didn't honor the notice of offer of work. They didn't apply, even though they made an agreement with Workmen's Comp to work me for 1 year. And it was deemed accepted whether I turned it in or not, and I had 20 days to comply or think it over if I wanted a change in job or retire, etc., etc. Well, I asked for Eureka Run 10 o'clock in the morning bid, and that I was hired in 2002, and that I had 200 employees underneath me, and there was work available, and that anybody who works underneath me, I get paid for that day, and it's a 24-hour operation, 24 hours a day, and there's 400 truck drivers there. And I should note that I've been waiting for a phone call or registered mail to return to work, in which they are not complying with the notice of offer of work, and they're not completing their agreement that they made. In other words, they're in violation of their own agreement. So I needed to be enforced by Judge Grill in the settlement conference. I'm waiting for a court date from Modesto Legal Clinic because we were waiting for a document to get a legal document stating that I have a severe profound hearing impairment, which states that I had a hearing problem since 2006. And they haven't accommodated me with any listening device or whatsoever since 2006. Okay? So on December 7, 2010, they just flat out sent me home, and they didn't pay me for the day. And I wasn't represented by the union on interrogation by the dispatcher. He told me the shop steward is on his way, and he told me to sit down. And I was supposed to work first and grieve later. It didn't happen. And they just flat out sent me home. Again, I hate to repeat myself, but I have a severe profound hearing impairment. The panel hearing was put in abyss.
And I told them, are you an authority on severe profound hearing impairment? And they just flat out sent me home. I had a settlement conference, and Judge Gill was off that day, and Adam Stewart was my attorney, workman comp attorney at the time. The administrative judge suggested that they put me back to work due to the fact that the Safeway attorney was on the phone with Safeway, and Adam Stewart approached me, and my wife was there and asked me how long I could work for. And I thought that was peculiar because I had a notice of offer of work guaranteed or work for 1 year. Which they didn't comply to. So that was the second time. The first time they violated the time limits in the contract, and they didn't put me back to work like they did for 1,500 other Teamsters. The second time was the administrative judge suggesting that they put me to work, and the Safeway attorney must have told Adam Stewart, I don't know, because when he asked me how long I could work for, and he left, a lady or a secretary came up to us and told us to go to the lunchroom, and then later told us to go home. So that was the second time. The third time, Mr. or Mrs. MORLES, Safeway Private Insurance from Arizona, sent me a letter, or sent my attorney a letter honoring the notice of offer of work, suggesting that I should sign it and send it to Arizona, which I did registered mail in 2013. My attorney, Modesto Legal Clinic, sent me a letter to report to work immediately. I did so. Safeway and the union did not comply, or the union didn't take any action, and even though that they were aware of, or I made them aware of, that I had a severe profound hearing impairment to their attorney, and I also sent them a copy of a document of an examination showing and stating with a prescription that I had a severe profound hearing impairment, and they ignored it. In fact, I asked for arbitration, and the union attorney denied it, but suggested or mentioned the fact that we know you have a disability issue, and that arbitration is refused, and that you could pursue it under workman's comp if you wish to do so. At that point, I figured I exhausted the union system, whatever it is. I exhausted it, and now it's in workman's comp's lap. So at that point, they didn't comply. They put it on workman's comp to comply, so I'm asking workman's comp to enforce a notice of offer of work, and I'm asking for trial because I'm assuming the fact that they're in violation of 2009 Discrimination Act against severe profound hearing impairment or people with hearing impairment, and that the union did not comply with federal law. So I could be wrong or I could be right, I don't know. So, but I'm asking to go to trial so that the judge can make a decision on that, for the fact that I've been sitting at home waiting for a phone call or registered mail to report to work since December 7, 2010, and I need a court order to get all back pay and benefits 7 days a week, 14 hours a day, plus my lifetime medical to be restored, a medical, prescription drug, Delta dental, eyeglasses, and I don't know about hearing impairment, and then I'm at 90%. So I don't know what the court wants to do about that, but I'm asking for it to be reinstated. Due to the fact that all disciplinary action was denied on December 17, 2010, because the grievance was received by Teamster Local 439, Mr. Neiswanger, on December 17. It was stamped, received, Local 439, on December 17, 2010. That's more than 10 days. And I should note they didn't respond in 10 days on December 25th, 2010, when they were required to do so according to contractual procedures, and they violated the time limits and also Step 1 and Step 2 of the contract, in which they didn't comply, and the union didn't enforce contractual procedures, let alone a hearing device, or assisted hearing device at the panel hearing, and they put it in a bus and sent me home. So I'm asking to go to trial for the court to get a court order for back pay and benefits and automatic retirement on my birthday on September 7, 2013. and that everything to be restored, back pay and benefits and pension and RSVP. I don't make any payments. It's a premium lifetime medical. I need that reinstated, and I don't make no premium payments after I retire. None. And I need that reinstated or made whole again, including my pension, my back pay, and health and welfare to be paid. Because my wife is sick and she ended up in the hospital, and it's really hard. I have to pay for that bill. So if they could pay for the health and welfare for the year of 2013, I would appreciate it, and then I wouldn't have to make payments to the hospital. And the union put it on workman's comp to resolve these issues. They said I could pursue it under workman's comp, so that's why I'm bringing all that up in the union matter. I'm bringing it up for the fact that they didn't deal with the issues of severe profound hearing impairment, and the fact they didn't deal with the issue, the fact that the dispatcher on December 6, 2010 changed the time on my logs from 10:30 to 11:15, taking the time from the second time clock. I should note that and put me in violation of Department of Transportation and company policy. And he accused me on December 7, 2010 of falsifying documents or intent to falsify documents that he altered or falsified on December 6, 2010. And I should also note that the onboard automatic recording device in the tractor is tamper-proof. Tamper-proof. And you also have to have a key in order to change anything. And the dispatcher is the only one with the key. I'm assuming that's correct because I've seen them change the time on logs before or corrected them, whatever the case is. I don't know what authority they have on changing logs. Under the Department of Transportation 395.15, 395.16, and the interpretation in 395.8, it states in there that they're not allowed to alter or change anything on them logs. If there's a problem, there's to write in the remarks section what the problem is. And what the problem is, and make the driver aware. They didn't do so on December 7, 2010. And so I should note for the record that they didn't honor the notice of offer of work at least 3 times. They denied to put me back to work. And that I have a permanent disability according to the QME report. And that it states in there that I could do my customary duties on my job. And I should also note that according to the legal document that I have that was requested by Judge Grill in the settlement conference to 2 attorneys that I just received, that I have a severe profound hearing impairment since 2006, and that I lip read. I'm not good at it yet, but I'm learning, and I'm also trying to learn sign language. But the point is, I've never been accommodated at any time since 2006, and they need to accommodate me with hearing aids because I bought my own, and they're old, and they don't work at all. And I need something that blocks out background noise and stuff like that from the reaper. So again, I'm asking for a court order to be returned to work, all back pay and benefits, and health and welfare, and my lifetime medical, according to the 2009 Disability Act, and also to the contract, okay? Because I didn't do nothing wrong on December 7, 2010. The only thing I received was a notice of offer of work, and they just flat out sent me home, and I was also on FMLA. So this is my request for trial, or for Judge Grill to consider sending this case to trial to resolve the issues of the Disability Act of 2009, hearing impairment. I would appreciate it if we did that, and I also would appreciate the fact that he enforced the notice of offer of work and return me to work according to the contract. And I would appreciate that. And I should point out that the fact is that they've been refusing me, denying me medical treatments. I don't get paid every week or every 2 weeks since 3/21/2009 or 4/17/2009. They refuse me to put me back to work when I have a full duty release to go to work. They won't accommodate me with hearing aids. They won't honor the notice of offer of work. I hate to keep repeating myself, but I do have a severe profound hearing impairment, and my life is on the line. And I need the notice of offer of work to be enforced for the fact that my daughter needs one more year at the university to get her BA in biology. One more year. I need that one more year. And they made an agreement with Workmen's Comp to work me that 1 year. And I'm asking for it to be enforced so that my daughter can finish at the university. And that was a guarantee for 1 year. And I didn't start one day on the 10 o'clock shift Eureka run. So I'm asking Judge Grill to consider that. And I'm also asking him to consider the fact that a double standard is the application of different sets of principles for similar situations, or two different people in the same situation. A double standard may take the form of an instance in which certain concepts, often, for example, a word, phrase, social norm, or rule, are perceived as acceptable to be applied by one group of people, but are considered unacceptable, taboo, when applied by another group. The concept of double standard has long been applied, as early as 1872, to different moral structures on men versus women. A double standard, thus, can be described as a sort of biased, morally unfair suspension towards a certain group of the principle that all are equal in their freedoms. Such double standards are seen as unjustified because they violate a basic maxim of modern legal jurisprudence that all parties should stand equal before the law. Double standards also violate the principle of justice, known as impartiality, which is based on the assumption that the same standard should be applied to all people without regard to subjective bias or favoritism based on social class, rank, ethnicity, gender, religion, sexual orientation, age, or other distinctions. A double standard violates this principle by holding different people accountable according to different standards. The phrase "life is not fair" may be invoked in order to mollify concerns over double standards. I'm hoping that Judge Gill considers this statement for the fact that if the company doesn't comply with the time limits under the contract, 1,500 Teamsters are returned to work immediately. Well, they didn't put me back to work. And James Williams, our transportation manager, knows all this. He knows everything. He knows what's going on. But he didn't comply. He didn't put me to work, back to work like they do for 1,500 Teamsters or 400 truck drivers. I should note that for the record. And I should also note for the record that they didn't accommodate me with any listening device whatsoever since 2006. So I'm asking Judge Grill to consider this and to enforce a notice of offer of work because my life is on the line here and I have no lifetime medical, I have no medical coverage whatsoever, even though I paid for it in 2002. I paid $3,000 plus to cover for 5 years so that I could retire at any time. And I should also note to the fact that Safeway called the health and welfare and said I didn't work at Safeway. And that barred me from getting any kind of lifetime medical or asking them to keep me covered. That didn't happen. So, and the fact that the dispatcher who falsified my logs by taking the time off the second time clock, and they have a no-fault attendance policy, and they applied it to everybody else, but they didn't apply it to me. No-fault attendance policy that's been as part of the company policy for 10 years that I've been there, and from my understanding, it's been on there for at least 20 years. No-fault attendance policy. So, and the fact that I never received any registered mail or anything else stating that I didn't work at Safeway at any time, not within the time limits. Okay? So, and the fact that they just flat out sent me home and they didn't pay me on December 7th, 2010. He took my time card or my trip sheet or whatever it is and disposed of it. I don't know where it went. It disappeared, and I never got paid for that day. So that's why I'm asking for back pay from December 7th, 2010. And I hope Judge Bill considers again to enforce a notice of offer of work and that to send this case to trial. And I hope he considers this seriously for the fact that I have a hearing impairment and that the union should be held responsible under the Disability Act of 2009. And that's my statement for the court. So this is, so I hope Judge Bill considers the double standards.